Hello and welcome. Do you have a fair hearing scheduled and you're scheduled to go to that hearing without a lawyer? This helpful hints and tips narrated PowerPoint is designed for VR customers who are unfamiliar with that process but have a hearing scheduled and need to know what the best way to approach it is and what some of the things that they can do and the roles that are expected and those kinds of things. So we hope this is helpful, and without further ado, let's jump right in. So the purpose of this guide is to provide some helpful hints to a VR customer as they move forward with a fair hearing. Please note these hints are not intended as a substitute for legal advice. You may wish to contact your local disabilities rights attorney advocacy center or consult with a lawyer admitted to the bar in your community if you require further assistance. This is purely designed for folks who are wanting to go in and represent themselves in a hearing. So let's take a look. Communicating with the hearing officer. What can I do? What are the roles? What can I not do? You can't talk directly to the fair hearing officer unless the other party is also present. That's called an ex parte communication. You can't talk to a hearing officer about the merits of the case without both parties present. And it's important to remember that that's designed to keep the hearing fair across the board. That's designed to prevent one side from going and sort of getting into a hearing officer's ear and convincing them of some material aspect of the case without both parties being able to have that discussion. Whenever you send a letter or other written communication to the fair hearing officer, you must copy the other party at the same time. If the hearing officer responds to you, they will copy the other party as well. Again, it's designed to, in any communication with the hearing officer is designed to, so that both parties can be a part of that. And it'll be helpful to you to keep a separate file of all the communications you have with the hearing officer and the other party about your appeal. Just kind of helps to build the file in your record so that you have a clear record of exactly what transpired. So what can I do? You can negotiate directly with the other party at any time. Be aware that an agreement can be reached at any time. If the other party has a lawyer, you must negotiate with that lawyer or get that lawyer's permission to contact the other party directly. Again, the idea is to keep it fair. So if that other party has a lawyer, again, you want to consider having a lawyer, you certainly can. But if that person does have representation, you're required to talk first with that person and get that person's permission to talk directly to the other party. And you can also withdraw your request for hearing at any time by sending a letter to the other party and the fair hearing officer. If you and the agency have reached a new agreement, for example, you can withdraw that request for hearing at any time. But you have to communicate that to both parties. I'm preparing for direct examination, which is sort of asking questions of a witness. What do I do? First, you want to frame the questions you want to raise. Remember, you're building a case here, and in building a case, you want to build a solid foundation, and then it's almost like building a house. You want to kind of decide where the walls are going to be, what's going to define the issues of the case, and then you want to present that in an organized way. So preparing a list of questions makes good sense. Hearing officers need factual information to make decisions. They're not going to make decisions based on emotion. So in order for you to establish something into the record, you have to establish that fact by a series of question and answers with a witness. And that's how things get into a record. So you ask appropriate questions based on facts. What do you know about my situation? As opposed to an opinion-based question, you don't know anything about my situation, do you? Or a leading question, don't you think that it's bad that, or that's a leading question. You allowed this to happen, didn't you? Or you don't like me, do you? Those are all emotion-based or leading questions that don't do much to establish facts. A factual question might be, what do you know about my situation? What happened on this day? Those are some of the things. Remember that facts are what's going to decide the case, not necessarily emotion. What about handling witnesses? What happens then? Fair hearing officers are limited in how that much they can assist you in asking questions. In a lot of cases, a fair hearing officer knows that you're not a lawyer. right? So even though you're going to be expected, and we'll talk about expectations here in just a couple minutes, but they're going to expect you to act in certain ways and be respectful and organized and be on time and those kinds of things. But they know you're not a lawyer. So they're going to occasionally be able to help you frame a question, but they're limited in their ability to do that because they can't go out of their way to do that with you and then not go out of their way to do that with the other party. Again, it's a fair hearing. So you're going to want to be prepared with questions that are well designed, that are well indicated to draw, and well designed to draw facts. Call your witnesses. Ensure they're aware of the time and location of the hearing. Alert the other party and the fair hearing officer as soon as possible if you learn of any potential problems with a witness and their attendance. If a hearing is postponed or canceled, you are the one responsible for notifying your witnesses. The fair hearing officer is not going to do that. The other thing to know is the fair hearing officer doesn't provide compensation for anybody who attends the hearing. They don't pay travel costs. They don't do those kinds of things. They don't pay lost wages for people who don't go to work. So, that's something that your witnesses need to be aware of. And simply listing a witness on the witness list doesn't guarantee that witness's attendance. Ideally, you should communicate with the other side regarding witness attendance. In other words, if you've got a witness that you'd like to have, you're responsible for making sure that witness appears. Not the hearing officer is not responsible for that. The agency is not responsible for that. So just kind of know that if they're your witness, they're your responsibility. Before the hearing formally begins, the fair hearing officer will ask if there's anything, you're in the room now, and the fair hearing officer will ask if there's anything that needs to be discussed to make the fair hearing go more smoothly. Again, keep in mind that you can come to an agreement at any time. Oftentimes, there might be a specific issue that pops up that once it's clarified, and this came up when the independent hearing officers were working on these sort of success tips. Oftentimes, it's something that's clarified just in that moment where people get together that leads to the groundwork for an agreement. So being open to that is helpful. But you should let the hearing officer know right away if any of your witnesses have scheduling limitations that you've just learned about, if you have any problems with your exhibits or the other party's exhibit packet, if you need to take a break at certain time for medical reasons, if you have a new advocate, certainly if you've got an attorney, or if you've got a disability advocate with you, for example, or anything else that might affect the flow of a hearing. Again, the hearing officer's role here is to, sort of maintain the integrity of the record and also to make sure the hearing is fair. So you can assist them in very specific ways. And we'll talk a little bit more about that as we go along here. What's expected of me as I'm representing myself in a hearing? During all contacts with the fair hearing officer and with the other party, you're going to be expected to be prepared, be respectful, be honest, be cooperative, and be on time. The hearing officer knows that you're not a lawyer, but you are going to be expected to behave as though you're adhering to those same sort of codes of conduct, if you will. So being prepared, respectful, honest, cooperative, and on time are big pieces of that. Although the fair hearing can feel overwhelming, it's important to remain calm and focused on your goal. We'll reiterate that later, but a hearing is based on facts. It's not based on emotion. So when you're in a hearing, you need to, the best thing you can do for your case is to remain calm and focused on your goal and remain open to kind of building consensus or connection with the other party. Because again, you're in here trying to fundamentally, at the end of the day, solve a problem. And if you can find your way to solving a problem, you're going to be much more able to do that if you're calm and you're focused. Tips for keeping calm and staying focused. Remember that the other party, they're not your enemies. And oftentimes their skills and experience can be really helpful to you if you kind of maintain your cool and professional attitude and ask for assistance when you need it. They've been through this process before. They've oftentimes even maybe have solved complex problems similar to yours before, or they've solved a problem with kind of a unique approach that you might not be aware of. So remember that their expertise and their experience can oftentimes be helpful to you if you're open to it. And keeping in mind that everybody else at the fair hearing is probably a little uncomfortable too, including the staff and those kinds of things. Fair hearings and quasi-judicial hearings, which are, it's quasi-judicial, sort of an almost legal sort of, or almost judicial sort of hearing. They make people uncomfortable. So kind of knowing that you're not alone in that sometimes helps. Read everything you receive from the fair hearing officer and the other party carefully. Ask questions if you don't understand. Pretending to understand something isn't going to help you. And in fact, sometimes when something's clarified that way, it might even lead to you a little bit closer to being able to form an agreement, or a little bit closer maybe to understanding the nuance of somebody else's position or even your own. Listen carefully to the fair hearing officer's direction. Ask questions if you don't understand. Same idea. If they say something you're not quite sure what they're referring to or what they mean, ask for clarification. They'll be happy to give that to you. Follow the deadlines and the orders carefully. If you can't meet a deadline, ask for an extension. Don't know of a single hearing officer, if you've been prepared and focused and respectful and organized, can't think of too many hearing officers that wouldn't grant you an extension if something comes up. So, but again, the way that you ask, the way that you make that request sometimes makes all the difference. If you don't follow a fair hearing officer's orders, just bear in mind that they have the ability to dismiss the case. So, if you want to give your case the best chance of moving forward, staying calm, focused, being prepared, respectful, on time, those are your best tools. And fair hearing officers at the end of the day base their decision on facts and not opinions and not emotion. So remember to keep the facts of the case foremost in your mind. It's really tempting to let the emotion of it seep in. And what I would invite you to do is let that take a back seat to the facts. Your best case is laid upon facts, and all decisions are made sort of by law based on facts. So it's not the emotion that's going to necessarily persuade somebody, it's the facts that are going to persuade somebody. Same idea here. The hearings can be really emotional. You may be tempted to yell or call other people's names, pound the table. Try not to do any of that. Ask for a break if you need one. Fair hearing officers do have the ability to delay or dismiss a case altogether, and you don't want that. Staying calm and focused is the very best way to help your case. And last but not least, a few things to keep in mind in a hearing scenario. Fair hearings don't know you, and they come to every case with an open mind, which means they're sort of looking at it with a fresh set of eyes. So it's important to remember that the case that you build methodically be organized and well presented, because that's the basis on which the decision is going to get made. Fair hearing officers also know that you're unrepresented. You're not a lawyer. And they're going to do the best they can and help you present your case without prejudicing either side. And again, they can't build your case for you. They can't do it at the expense of the other side, but they can certainly sort of help you along a little bit. Fair hearing officers act as facilitators during the proceedings. They don't have an opinion about you or the case. But their main job is to ensure the integrity of the hearing process, in other words, that it's fair. Their other main job is to make sure that the record is clean and clear. And you can do that by remaining calm and focused and presenting sort of an organized and logical case, and keeping your witness list organized, keeping your case organized, those kinds of things, so that when you present it, it's as clean and clear of a record as can be. Because remember, the next step in a process is an appeal, and that appeal is an evaluation of the record that's been created based on the legal merits. And if that hearing officer didn't do a good job of maintaining a clean and clear record, that's going to be kind of a bit of a mess. So the fair hearing officer is going to be concerned with the integrity of the hearing process, making sure it's fair, and making sure that record is clean, clear, and organized. And the duty within the hearing of the hearing officer is to maintain order, right? So that means they cut off testimony if they think it's irrelevant or inflammatory or any of those things. Again, their job is to make sure that the forum that is the fair hearing is one that's helpful and conducive to coming to an equitable decision. So there's a few things to keep in mind, a few success tips if you are going into a fair hearing and you're representing yourself. We hope these tips are helpful. Thanks again for joining us, and good luck in formulating and presenting your